Welcome to A Funny Thing Happened on the Way to the Funeral, my intriguing, funny, outrageous, and sublime stories about estates. Frank Sinatra, old blue eyes, chairman of the board, possibly the greatest pop singer to have ever lived, did something very interesting in his will. Frank was married to Nancy Sinatra from 1939 to 1951, and they had 3 children together. Nancy Jr., famous in her own right as a singer for These Boots Were Made for Walkin'. Frank Jr., also a singer, perhaps most famous for being kidnapped when he was 19 years old from the Hara Lake Tahoe Hotel, and his dad paid, in today's dollars, $2 million for Frank Jr.'s release. And the youngest, Tina, who did not want to be a singer, but was on, and you will hear her on the Sinatra Family 1968 Christmas album. Those were all of Frank's kids. Frank did remarry. He was married to Ava Gardner from 1951 to 1957, and he was married to Mia Farrow from 1966 to 1968, 12 years before Mia coupled with Woody Allen. That relationship, of course, famous for ending when it was revealed that Woody was in an intimate relationship with Mia's 21-year-old adopted daughter. That is the story for another episode. And finally, Frank was married to Barbara Marx, so named because she had been previously married to Zeppo Marx of the Marx Brothers from 1976 until his death in 1998. Okay, in his will, Frank made a whole bunch of specific bequests, gifts. His first wife, Nancy, received $250,000. His last wife, Barbara, received the bulk of the estate, including their home on Frank Sinatra Boulevard. How cool is that? Your name? Frank Sinatra. Where do you live? Frank Sinatra Boulevard. Pretty cool. Second and third wives, Ava and Mia, received nothing. And there was other trusts for the grandchildren, and he even left $50,000 to his friend Jilly Rizzo. Jilly was a saloon owner who became Frank's friend and ultimately his chief aide. Nancy Jr., Frank Jr., and Tina each got $200,000. Frank Jr. got his father's sheet music, and the kids also got the residue of the estate. Frank did something interesting in his will. There's a clause in his will, a no contest clause. If any beneficiary, anybody who received anything in the will, contested the will, they would be disinherited and receive nothing. In terrorem, a threat. Can you put a clause like that in your will, and is it enforceable? The answer is yes, you can. I go back to the case of Cook versus Turner from the Court of Exchequer in 1846. The court found that Sir Gregory Page Turner, despite having been duly confirmed to be a lunatic by a jury, had a no contest clause in his will, and it was enforceable. There's a couple of hiccups. Number one, if you're going to put such a clause in, you have to have a gift over. What happens to the money that someone was going to get if they are disinherited? The will has to indicate who should get it, if not them. And secondly, it can't be against public policy. So in family law, a spouse is entitled to half the matrimonial property. The same thing applies in an estate. You can't leave less than half the matrimonial property to your spouse. And if you tried to put in a clause that said, I'm going to leave a quarter to my spouse, and if my spouse contests it, they will get nothing, well, that's not a duly constituted will, and it would be struck out. If the no contest clause in your will meets those 2 requirements, then it's probably enforceable and valid. You can put in an in terrorem clause in your will. Fun fact, there is only one recorded full-length Rat Pack concert. Frank, Dean Martin, and Sammy Davis Jr. Interestingly, with a young Johnny Carson as the MC. It is available on YouTube. I highly recommend.